You slip in the stockroom. Your wrist takes the fall. And through the fog of pain, the very next sentence you hear may decide whether the system pays for everything or for nothing. Hey, let's not make this a big deal. We'll take care of you. Every year, millions of Americans get hurt on the job. Most have no idea that a safety net older than their grandparents is already sitting there, prepaid, waiting. It's called workers' compensation. No lawsuit, no proving your boss did anything wrong. Hurt at work means covered, in every state, from your very first day on the clock. But the net has holes, and employers and insurance companies know exactly where they are. Miss one deadline that's measured in days, sign one wrong form, accept one friendly handshake offer, and your claim can die before it's even born. In the next 10 minutes, the 100-year-old deal behind workers' comp, the first 24 hours that make or break your claim, what it actually pays, the 6 traps to dodge, when you can sue for far more, and exactly what to do if they deny you. Let's unlock your right. Workers' compensation is a deal struck about a century ago, and it's important to understand both halves. Your half. You generally gave up the right to sue your employer for negligence when you're hurt at work. Their half, they pay for your injury no matter whose fault it was. That phrase, no fault, is the heart of the entire system. You tripped over your own feet? Covered. You lifted the box wrong? Covered. Nobody did anything wrong at all? Still covered. You don't need to prove negligence. You don't need a lawyer just to start a claim. You need exactly 2 things. You were working and you got hurt. And it's broader than accidents. Occupational illness, a back that gave out over years of lifting, carpal tunnel from a keyboard, covered from your first day on the job. No waiting period, no probation. What you do on day 1 is worth more than anything a lawyer can do for you in month 6. First, report it, in writing, the same day. A text or an email to your supervisor works. What happened, when, where, who saw it? The gap between the injury and the report is the #1 weapon insurers use to kill claims. If it really happened Monday, why did you report it Thursday? Second, see a doctor immediately and say the words, "This happened at work," so they go into your medical record. That sentence on day 1 is gold. Third, collect while it's fresh. Photos of the wet floor, the broken ladder, the missing guard, names of every witness. Fourth, ask for the claim form. In most states, your employer must provide it. Reporting to your boss and filing the claim are 2 different steps, and you need both. So what's in the package? First, medical care. 100% of treatment for the work injury. No deductible. No copay. Surgery, therapy, medication, the ambulance. The insurer pays, not you. Second, lost wages. While you can't work, you receive roughly 2/3 of your average weekly wage in most states. And here's the part people miss. It's tax-free, which brings it much closer to your real take-home pay than it sounds. There is a state maximum, and in some states that cap tops out over $1,700 a week. Third, the long tail. If the injury leaves permanent damage, you're owed an additional permanent disability award. Many states also pay your mileage to medical appointments and retraining if you can't return to your old job. What comp does not pay, pain and suffering. That's the price of the no-fault deal. But as you'll see in a few minutes, there are doors that lead to much bigger money. Now, the part that kills more valid claims than anything else, deadlines. There are 2 separate clocks, and most people only know about one. Clock 1, telling your employer. 30 days is common. California, New York, Florida. But some states are brutal. South Dakota wants written notice within 3 business days. Wyoming, 72 hours. Blow this clock and you may lose everything before you've even seen a doctor. Clock 2. Filing the formal claim with the state. Most states give you 1 to 2 years. West Virginia, 6 months. Massachusetts, 4 years. Different state, different rules. One mercy. For repetitive injuries, the back, the wrists, the hearing loss, the clock generally starts when you knew or should have known the condition was work-related, not when the damage silently began. The safe play is always the same. Report today, file early. Let the deadlines chase someone else. Here's where good claims go to die. 6 traps. Watch for every one. Don't file. We'll pay your bills in cash. This has a name: claim suppression. Your health insurance excludes work injuries. The friendly promise evaporates the day you need surgery, and in most states you legally cannot waive your comp rights anyway. 2. You're an independent contractor. You're not covered. The label on your paycheck doesn't decide. The reality of who controls your work does. Misclassification is everywhere, and states look straight through it. 3. The company doctor shrug. In some states, the employer picks your first doctor. You almost always have the right to a second opinion or to change doctors. Use it if the diagnosis feels like it was written by the insurance company. 4. The recorded statement. The adjuster's friendly call is a fishing trip for the words pre-existing condition. You generally aren't required to give one without advice. 5. The fast, low-ball settlement. Money on the table before anyone knows how bad the injury really is. 6. It was your fault, so you get nothing. You already know better. It's a no-fault system. The no-lawsuit deal only protects your employer. It does not protect anyone else. And that's where the bigger money lives. The forklift had a defective part? You can sue the manufacturer. Hit by a driver while making deliveries? You can sue that driver. Hurt by another company's contractor on a shared site? Fair game. These are called third-party claims. They run alongside your comp claim, and they pay what comp never will, including pain and suffering. And then there's Texas. Texas is the only state where workers' comp is truly optional, and roughly a quarter of private employers there opt out. If yours is one of them, the shield disappears. You can sue your employer directly for negligence, and the law strips away their best defenses. Finally, if an employer intentionally harms a worker, most states say the shield never applied at all. Say it with me from the last 3 videos. Retaliation is illegal. Firing you for filing a comp claim, cutting your hours, the sudden demotion, the schedule that makes your physical therapy impossible. Every state makes retaliation for a workers' comp claim illegal. Now, the honest fine print? Comp doesn't freeze your job. You can still be laid off for real, unrelated reasons while you're healing. What's illegal is punishment because you filed. So document the timeline, the claim date, then every negative thing that follows. Timing tells the story, and juries hate this play. A strong retaliation case can end up worth more than the comp claim underneath it. If that's where you are, our wrongful termination guide is on this channel. Here's a number that should make you angry, then determined. Depending on the state, anywhere from 1 in 10 to nearly half of comp claims get denied at first. Insurers deny because denial is cheap. Most people simply give up. Don't. A denial is not a verdict. It's an opening move. Every state has an appeal process before a workers' comp board or judge, and the deadlines to appeal are short, sometimes 30 days. This is the moment to bring in a lawyer. And here's why it costs less than you fear. Workers' comp attorney fees are capped and regulated by state law, typically somewhere between 10 and 25%. Approved by the judge. Paid only out of what they win for you. Nothing up front. and claimants with a lawyer are roughly 3 times more likely to win the appeal. The insurance company has professionals working your file. From the denial letter forward, you should too. So, hurt at work? Here's your path, start to finish. Report it in writing today, even if it seems minor. Sprains become surgeries. See a doctor and put "this happened at work" in the record. Ask for the claim form and actually file it. Reporting is not filing. Keep your photos, your witnesses, your paperwork. Dodge the 6 traps, especially the cash handshake and the fast settlement. Watch both clocks. And if the denial letter comes, appeal, with a capped fee lawyer who only gets paid if you do. Workers' comp is a right you've already paid for. It was baked into the deal the day you were hired. The only way to lose it is not knowing how to use it. If a firing followed your injury, watch our Wrongful Termination guide next. And if your employer owes you hours too, the off-the-clock video pairs with this one. Subscribe, because every week we take one right that powerful people hope you never read about, and we unlock it.